Okay, good evening and welcome to the Sanlam Private Wealth webinar. Tonight we're going to be focusing on the role of trust in global estate planning. My name is Reginald Labuskaghni. I head up the product and strategy for the company, and I'm joined tonight by Stanley Braun, our head of tax and fiduciary. Welcome, Stanley.
Thank you.
But I'd like to thank you for your time tonight and hope that you find the evening informative. I'm sure it will be. Got quite a bit of detail to cover. Now, estate planning and specifically the use of trust is quite a complicated topic, and to try and get some detail out and some relevant detail, we've put together a case study that we'll try get through the case study and hopefully keep it quite practical. And I just want to remind you to please post any questions you might have in the Q&A section of the webinar. Most of you will hopefully be quite comfortable with that by now. We will try and get to some of these questions during the course of the webinar. If by any chance we don't get to them, we will send a recording probably about 2 weeks' time following the webinar to all participants, and we'll also answer all the questions and answers that are posted on the topic that will circulate to all the participants. Now, Stanley, the world is in the midst of one of the greatest migrations of wealth from the current baby boomer generation, some of the silent generation, to Generation X and the millennials. Now, this transition of accumulation and the disinvestment and transfer of these assets is a very complex issue. Now, most individuals are either not properly structured for it or they haven't been well advised. So if you can maybe just, before we get into this case study, just give a high-level view of what role the trust can play in global estate planning.
Thank you, Reginald, and thank you everyone for joining this evening. I think that if one look at global estate planning, if we talk about global estate planning, and as I said before, and as people will also know that we live in a world where people has got diversified investments, whether it's by the form of a share portfolio or whether it's by the form of having other type of assets in South Africa and also abroad. And one would also like to ensure that the wealth that one has started to create over the years, that wealth actually continues from generation to generation. And one of the vehicles that one can definitely make use of in order to ensure that the assets and the wealth that you actually have accumulated over the years really moves from one generation to the next generation, but you're keeping it and you continue to grow it in that particular generations, is trust. So trust still plays a key role for a lot of our clients, especially, and I would believe for other people as well, because a lot of the wealth has been started to grow in those specific vehicles for a lot of our clients because of grandparents and great-grandparents that has actually started the trust, and it's got this longevity. So in terms of when we look at trust, it still holds the benefit in terms of the protection of the assets against creditors. It also still holds the view that or the fact that when you actually pass away, that those assets in the trust doesn't form part of your estate. So from an estate duty point of view, yes, you save on estate duty taxes that is payable to the revenue service as the date of death. In addition to that, also what one also can take into account that there's no executor's fees or administration of that specific assets when one just looks at the assets in one's personal estate. In addition to that, the offshore trust can also play a similar role for assets that you've got offshore. So people who have externalized assets via their foreign allowance over the years has started to accumulate assets offshore. And the question is, now that the assets is offshore and we want to also protect those specific assets for the next generations, and so that wealth can continue to grow for the next generations, the offshore trust can play a similar role like the local trust to ensure that it is in a vehicle that is protected, and it's a vehicle that like a human being, you pass away, but that vehicle can actually continue for the benefit of generations. And I think one of the things that we also see quite a lot happening now in the industry is that we as human beings has got this longer lifespan, so we live quite long. And what happens is that some people start become or there's symptoms of dementia showing or Alzheimer's showing, and so they're becoming incapable of looking after themselves. And sometimes the benefit that you can actually see within the trust is that we are the corporate trustee on these trusts, that although that is busy taking place and the person can't handle or not capable of handling their own affairs, the trustees can actually continue to take care of that person. So there are still reasons to have a trust, it does play a key role for a lot of the clients who have started their wealth with interest to see how can we continue keeping that wealth and growing that wealth outside of the estate of the beneficiaries, but protecting it for them as well.
Okay. Yeah, let's maybe unpack this case study, because I think everything you've mentioned now, we'll start getting to some of those details, and there's also some of the things that we need to be aware of as conditions and circumstances change, whether it's tax legislation or personal circumstances, how we need to review that. So maybe if we can just put that slide on the screen now. So in this case study, we're basically looking at a 90 million rand estate with basically in this whole chain of events, there's basically the grandfather, age 85, father of children and grandchildren, essentially. Now, if you look at this, there's essentially 30 million rands of assets invested abroad, and that's mainly in a portfolio of shares, and those shares are predominantly in the UK and the US, listed in those jurisdictions. And if you look at the balance, the 60 million rand is invested locally in South Africa across a portfolio of shares and immovable property. At this stage, the grandfather is healthy, but it's, as you mentioned, in this we see this quite a bit, and we've probably got some personal experience with this in different cases, but early signs of dementia starting to creep in, so we'll deal with that one as well. And then both the children and grandchildren at this stage live in South Africa, and that's quite an important point we'll look at just now. And the main intention of this grandfather is to look after the grandchildren, make sure they are, because at this stage the children themselves are well looked after, and his intention is obviously making sure that the grandchildren are financially looked after. So maybe if we just dig into this to start off with, where do you see a local trust playing a role, and what are some of the key factors one must take into account when we look at the local trust?
Yes. So if you look at the local trust, and if we take this specific scenario, then the local trust can definitely play a key role, because the client is, for example, in an early stage, or there is signs that start showing that there might be the dementia starting to creep in. So what one can do is to say, when you look at the estate planning of this client, let's assume that he keeps all of the assets in his personal name. What will basically happen at date of death, as we know, he bequeaths the assets to his children or to his grandchildren. That will attract capital gains taxes at date of death. That will also attract estate duty at date of death. And then you leave it in the hands of the children and or the grandchildren, and what happens is that they have the assets grows, it is unprotected, and then in addition to that, when they pass away one day, it will also be subject to estate duty and CGT at the date of death. And what you want to do is then to say, if that is the case, is it not possible that one can start looking at setting up a trust? He is at the age of 85, and perhaps it's a good idea to say that if he lives off these funds during his lifetime still, and that there is the possibility that it will go into the stage of dementia, it will actually perhaps be beneficial to transfer some of these assets into a local trust by way of donation and pay the donation tax, which will be equal to your estate duty. And then what we can also think of is saying, if you don't want to do it by way of a donation, then you can actually do it by way of a loan account, and then we'll have to look at what is the tax consequences. For example, if it's an interest-free loan, what is the local, the Section 7C taxes around it. So those will be some of the aspects we will look at, but it does start to make sense to say, if you put it in a local trust, and the father, who is the grandfather of the grandchildren, gets into the fast stages of dementia, then what you will typically see is that people that is not capable of handling their own affairs, those estates of that person basically gets frozen. The question is, who's going to look after the father, who's going to take care of his expenses, and also what happens is there's two things that we need to keep in mind. When someone gets to that stage, even if you have the power of attorney, that power of attorney you cannot use anymore, because that power of attorney then falls away, number one. Number two, we have to look at the process of curatorship and put all of his assets under curatorship. And number three is, when we look at that at his date of death, then we look at estate duty and CGT, but we've actually put the assets into the trust, whether it's by way of a donation to pay our donations tax, or by way of a loan account, and we basically pay the Section 7C donations tax. Then basically what we do is, if he does get to the stage where we know that he will have the case of dementia and is declared incapable of handling his own affairs, the trust can take care of him because of the assets within the trust, number one. Number two is those assets falls outside of his estate for estate duty tax purposes. Number three, we don't have to go through a curatorship process for him. And number four, the other fact that we can look at is that one of the things is that the will cannot be changed when someone is incapable of handling their own affairs. And number two is the curatorship can't allow you to change that will either. So what you want to do is then to know that yes, the will has been drawn up, the assets is now, or most of the assets already in the trust that can take care of the father or the grandfather, and basically the value of the growth of those assets within the trust basically takes place outside of his estate. So the next generation will then basically receive and hold the benefits going forward, knowing that those assets will then continue to remain within the trust and to take care of the rest of all of the next generation, basically. Yeah.
Okay. Now, Sandy, what we find tends to happen, and we'll get onto the offshore trust because there'll be similar questions on that side, but sometimes these kids don't stay in South Africa, or even the grandchildren might go overseas to study. They get a green card in America and they end up staying there. I mean, what do you do in circumstances like that? How do you review the trust? What do you have to think about when that happens? And we see that quite a bit nowadays with our clients. So what's the advice around that? How do you review that?
Yeah, we do get that quite a lot that comes past our desk, and I think one must just take a step back. And when we talk about global estate planning and the role that a local and offshore trust can play within global estate planning, we need to look at the estate, the entire estate of the client. Number one, what are the objectives of the client, and make sure that we align all of that, whether it's now making use of the trust as the vehicles. And number three is who are the beneficiaries of the trust, and where are these beneficiaries situated. So if they are in South Africa, perfectly fine, then we can work with that with the beneficiaries that's within South Africa. But when we start to get to a point where we say we've got this local trust of the specific line, and we find out that the children are abroad, whether the children or the grandchildren are abroad, they've ceased their tax residency, or they've actually formally immigrated under the old legislation and ceased their tax residency, then it becomes a more complicated matter. And I think sometimes what we do still find in the industry is that people are unaware of the consequences. If your child is a US person, if your child is now in Australia, has settled there and is now taken up residency in Australia, if your child is in a different jurisdiction, because some of these jurisdictions doesn't look favorable upon offshore trust. So it's important when we look at global estate planning and we talk about using trust as a vehicle, as part of your global estate planning. What is important to note is that you look at the entirety of the plan, of the trust that can play a key role, but also to look who's the beneficiaries of the trust. And making sure that if the beneficiaries of their trust is already located abroad and they have ceased their tax residency, or they are intending to cease their tax residency, then we have to ask ourselves, will the tax actually serve the purpose that we intended it to serve at that point in time? And that is why I normally tell my clients where it is the family that when we sit around the table, it's to review these affairs on an annual basis to make sure that if the children decide we're going to start studying abroad or we're going to start working abroad, to make sure that when we look at the local trust or we look at the offshore trust, what's the implications should these children decide to settle abroad, live abroad, get married, say I'm getting a passport in the UK and I'm taking up my citizenship and becoming a resident in the US, etc. Because the tax implications for a local trust is huge. And I think that sometimes some of these things get to our desk, then the children's already abroad, they've already ceased their tax residency, and now the question is how do we get out of it? And it's very difficult to actually get out of a situation like that. So when we talk about, and I don't want to hammer the point too much, but it's so key, it is so important, we see it often when we look at trust, that we just went into it because it made sense at that specific point in time. But reviewing it now, we have to ask ourselves if we make use of this vehicle as part of the global estate planning, or these vehicles are already in existence as part of our global estate planning, and we know that there are children or grandchildren that will be living abroad or moving abroad. We need to just stop and say, let's take a look at it and see, will it still serve the purpose, or what amendments must we make in order to make sure that better or the full benefit of whatever that child was supposed to receive or grandchild was supposed to receive can be extracted and be given in a different way to that specific beneficiary.
So Stan, I just want to go back to an example you use now, where you said that you're obviously reviewing if a child's going overseas with the intention of moving. There's
Yes.
certain, we'll get into the action of that in a second. And just compare that maybe with someone that's already moved and given up citizenship. You said that it's sometimes impossible or difficult circumstances to deal with it. Maybe just give 2 examples of what one can do in those situations, and what obviously it will vary from jurisdiction to jurisdiction.
Yeah.
But maybe just some examples of that for me.
Yeah. So some of the cases that we do see, and it's really difficult to go into all of the detail and to say what will the steps be within this, because that's like a topic all on its own, is to say when we look at, for example, a case where someone went to Australia, so the parents set up a trust. You've got a child or children that were beneficiaries of this trust, and what happened was the children moved abroad. They started studying abroad, they started working there, and they're living there. So what they have actually done over the years is they have settled in that specific country. They have never really given up the SA tax residency, so they haven't ceased their tax residency, but they actually settled already in Australia, for example. But you're still a beneficiary of the SA trust. And over the years, what we normally do is we make use of the conduit principle sometimes, or what we do, we vest the gains, the taxable income in those specific beneficiaries, and we basically still give it up in South Africa as if the person is still a taxpayer in South Africa. And basically that person never sometimes declare that income in Australia. And what we basically see is that when it comes to the point where we actually start looking at the situation, and the child says, no, but I'm living in Australia, I'm working there, I've got a passport, I'm already a resident there for all intents and purposes, and then subsequent to that specific date, the trust continued to vest amounts in that specific beneficiary, but you've done it as if the person is still a SA tax resident, then we've got a bit of a pickle here, because now we have to say, okay, fine, what do we do? Because number one, if that person ceased their tax residency, any gains must be taxed at 36% in the trust. But over the years, what we have done is we have assumed that person is still a tax resident, or that person already took up residency in Australia. So these are the factors, and it gets complicated, because at the end you have to say what is the best mechanism to actually address the situation. You have to rope in the right skills, the people with the right experience, just not locally in South Africa, but also sometimes you have to go abroad and actually start speaking to people there as well to say what is the position of the person. But the tax payment due in South Africa, in addition to the tax payment due in that specific jurisdiction, in whichever way they see that to be income or gains, can be huge. And the question is, sometimes it's difficult to get out of it if you're really so deep in it. And the question is, what is my liability towards South Africa? What's my liability towards that country? And basically, what am I left with? And if the lack of planning, which we see normally happens where people give up quite a bit of their wealth to pay taxes, and to say this trust is not going to work for us anymore, let's terminate it at the end. Yeah.
Okay. Just getting across to the offshore section of this, so how do you see offshore trust playing a role in this, specifically with these shares in these CITES jurisdictions?
Yeah. So I think most people are already familiar with the whole US CITES tax issues in the UK CITES taxes, or the UK inheritance taxes that we're looking at. And so a lot of clients still have got direct investments where the US, where they've got direct Apple shares, or they've got your Microsoft shares, etc. And then likewise also they've got UK CITES assets in the UK. And what normally happens is that, as you know, when you pass away, although there's a process within South Africa we follow, in broad terms, there's also a process in the US and in the UK, for example, that must be followed. So in the US, if it's a US CITES asset, it actually falls within the definition of that specific, of being a US CITES asset. That in that specific jurisdiction, you actually have to then basically pay US estate taxes, and that is basically on the sliding scale. And there's also a process to follow similar to what we would follow here in South Africa in order to administer an estate. So you have to report it to the US IRS within 9 months out of date of death. You have to pay the relevant taxes over to the US IRS. Likewise, the same principle and process there will be in the UK that we have to follow to report the estate and the assets within those specific jurisdictions. And if you look at it, so at date of death, you have to actually go through all of this process. You have to pay all of these taxes, you have to pay all of these additional fees to employ people or to get people in those specific jurisdictions to assist you, because we can't get onto the plane flight to the UK to the US to actually do it. We have to make use of the people that's sitting there that understands the process and the laws of that specific jurisdiction. In addition to that, there's executors fees on the administration of that specific assets in those specific estates. And actually thinking about it, if you actually look at it to say, I want to keep these assets abroad, I want these assets to continue to grow for the beneficiaries, and then perhaps it will be a good idea to say, should we not consider transferring these assets, whether on donation or loan account, into an offshore trust for the protection of the beneficiaries. Now, yes, there will be donations tax payable if you're going to donate the assets into the trust. Number two, yes, there will be taxes due if you actually transfer it over on a loan account, because it must be an interest-bearing loan account. So those aspects are there, but at date of death, you won't have the US CITES tax issues. You don't have to go through all the admin processes in the US or in the UK to report the estates. You don't have to be concerned about the executors fees on the value of those assets. The growth of those assets, similar to South Africa, will take place in that specific offshore trust. So the offshore trust and transferring those CITES assets into that trust can be beneficial if you actually look at the cost factor as well as on administrating of those specific assets. But also, if you look from the tax point of view, those assets consistently grow, and it grows and it grows. And when it starts growing and growing, in the US side, you on a sliding scale, so you pay more US taxes, estate taxes. And likewise in the UK, if it's above £325,000, you pay a flat 40% inheritance taxes on it. So one can say, yes, perhaps having that offshore trust and transferring that assets into the offshore trust might be beneficial, especially when a client is at the age of 85, 87, 90, 91, they can still manage their own affairs, but to say it's perhaps a good time to start looking at doing to transfer those assets into the offshore trust.
Just one thing I want to be clear on, is there capital gains tax in that transfer as well?
There will be capital gains. So if we talk about the portfolio of shares and you decide you're going to donate it into the offshore trust, it will trigger a capital gains tax event for you, and it will also have donations tax. But the legislation does make provision that a portion that you can get an uplift in the base cost of your assets based on the value of the donations tax that you actually had to pay over. So there is a formula in the legislation that allows you to actually get a step up in the base cost on those specific capital gains tax calculations. Yeah.
Maybe just on that, because we've got a question here from the audience asking, on the capital gains tax, what's the difference in the capital gains tax within the trust versus on the personal basis?
So when we look at the local trust and we talk about capital gains taxes, so basically in most cases clients make use of the conduit principle. So the assets will be in the trust, and if any of those, let's assume it's a share portfolio, some of the shares get sold, there's a capital gains tax event, then basically what people do is they vest that capital gain in the trust, in the capital beneficiaries, and basically you actually pay on your individual level. On your individual tax level, instead of paying 36% in the trust, you can pay up to a maximum of 18% in your personal name.
And on the offshore side?
On the offshore side, it happens, it's outside the jurisdiction of South Africa, so basically within that offshore trust, the CGT basically happens within that trust, and that basically, it will basically depend on how you actually advance the funds into that trust. So if it's a donation, then we have to look at the legislation in terms of how the attribution rules will work in terms of that. If it's based on loan account, then basically that happens only within the trust and it doesn't get attributed back to you.
And maybe Stanley, maybe just get into the different types of trust, because I think there's a lot of, also we got some questions on testamentary trust and how does that feature into all of this. So maybe just a comment on the different types of trusts, local and offshore.
Local. So in terms of the local trust, what some people prefer to do is to say that we don't have a trust at this point in time. We do have quite a bit of assets, but we're not going to transfer the assets currently into an inter vivos trust. And in doing so, what they say is, let's rather transfer these assets over to a trust at my date of death, which is a testamentary trust. So that trust basically comes into existence at your date of death, and that trust, that assets gets transferred over into the trust. So there's capital gains taxes, there's estate duty that needs to be paid on that. So basically, that will be a testamentary trust, and within your last will and testament, you can basically specifically set out in terms of who must be the capital income beneficiaries of the testamentary trust, etc., and then set out basically the distributions and to whom and how you want the distributions to take place. So you do have a bit of flexibility in there to also say it is your wish that the trustees of the testamentary trust will consider that if it is for the grandchildren, for example, that if it's for the education, so you've got that flexibility within the last will and testament to say that. So you've got the testamentary trust that comes into existence at your date of death, and then as a lot of people will be more familiar also with the inter vivos trust, so that's a trust that's in the living, so that's a trust that you can actually set up once you are alive. So that is what we predominantly use from a local side. And then from an offshore trust side, we do get a dry trust. So the one of the reasons why people will set up a dry trust is they would want the trust to be there offshore. So it's a dormant trust that they set up. So that trust, you've already set up who is the beneficiaries, or who's the income and capital beneficiaries of the trust. So it's similar to your inter vivos trust within South Africa that you basically set up offshore. And basically what people will do is they will keep that dormant trust there and say, fine, we've got the assets within our personal capacity. But at our date of death, whether it is going to the surviving spouse first and failing the surviving spouse to the dry trust or directly to the specific dry trust, that dry trust is already there in existence, waiting for the assets to be transferred into the dry trust at date of death. So basically what will happen is clients that says that we don't have the liquidity to pay the relevant taxes, the CGT or the donations taxes now, to transfer the assets into an offshore trust while we are alive. The dry trust would be a good option to sacrifice. Let's set up the dry trust. It is there, it is in existence, everything has already been set up, and at our date of death within the last will and testament for offshore assets, we basically bequeath all of those assets over into the offshore trust.
Just explain something to me, the difference in, let's say, in dry trust as an example, in your estate duty there compared to when you set up early on and transferring the assets in. I mean, just explain the difference there for me, please.
So once you set up, let's assume you set up an offshore trust, the offshore trust you set up already and you want to transfer the assets into the offshore trust. So as I said before, basically what you do, you've got an option. You've got your, you can do it by way of a donation and pay your donations tax, which is 20% up to the 30 million threshold, and then above that you will do the 25%, which is similar to your estate duty. So it's like paying estate duty in advance when you do it during your lifetime. Those assets goes into the trust, and basically the growth of those assets will be outside of your estate. For estate duty, at the date of death, you don't have the estate duty issue. Whereas if you say I'm leaving it up until the end, then up until the end means that whatever value those assets will be at your date of death and you bequeath to the dry trust, you will attract estate duty at 20% to 25%. If it's above 30 million, you will also have a capital gains tax event at that point as well.
And then, I mean, you touched on it earlier, but maybe just make it clear for me again, I mean, if you look at the ways of getting money into a trust, the difference between donation and loan, maybe just explain the difference there, especially obviously for the benefit of the audience, and the pros and cons on each one.
Yeah. So it depends on the set of circumstances of the client. So some clients will say, if I'm already an elderly person and what I want to do is I know that I've got X amount of time that I will still live. I've got like 10 or 5 or 7 years still basically to live, then some of these clients will say perhaps it's a good time for me to actually just transfer those assets into the trust at this specific point in time. And in doing so, they can actually do it by way of a donation. That will attract donations tax, and as I said, that is similar to your estate duty, just you're paying estate duty up front. So that will be one method of actually transferring it, and there will obviously, if there is a capital gains tax event, depending on the type of assets you transfer, and if it triggers a CGT event, you'll basically also have to take your CGT into account. But as I also said before, when we look at donations tax and CGT on the transferred assets into that offshore trust, then basically that there is a formula within the tax legislation that allows you to use a portion of the donations tax as part to get an uplift in the capital into the base cost before you do your capital gains tax calculation. So that will be the one part. But at date of death, those assets are outside of your estate for estate duty because you've already donated it, you've already paid estate duty on that in the form of donations tax. Then when we look at putting it over into a loan account, that is when we transfer the loan account, or we transfer the assets over into the trust and loan account. Remember, there's still capital gains taxes on the transfer if there's any CGT on it on the assets being transferred as a loan account. And then secondly, it's important that that loan account must be an interest-bearing loan account. The interest on that interest-bearing loan account that you calculate on an annual basis will form part of your income tax calculation that you have to give up to SARS. And then basically the value of that loan at your date of death will basically form part of your estate for estate duty. And what we typically do in that case is we actually bequeath that loan to the trustees of the offshore trust to actually cancel that loan at your date of death, meaning that the trustees does not have to repay the assets into your estate in order to settle that loan.
Thanks for that. So I think moving on to, again, special trusts, because there's one particular question that's come in here, and I don't know if this is something you'll be able to answer here, but firstly, what are special trusts and when they're used? And there's a very interesting, quite a technical question here. May you cede a living annuity to a special trust to look after a disabled person? And what will happen to the living annuity when the disabled person passes on and the trust is ended?
That is a property.
Yeah, no, I thought so. That's but just maybe touch on the special trust side of it and just see.
Yeah, so in terms of people normally set up a special trust, especially knowing that some of my clients actually do it in their last will and testament, knowing that one of the children are actually disabled. And then what they normally do is they say, when I pass away, I want these following assets to be transferred into the special trust, but the special trust is for the specific person, whether it's my son or my daughter, my brother or my sister, and then basically that special trust will then be registered with SARS as a special trust, and normally that special trust has got specific tax benefits like an individual when you go through the legislation. So a lot of people do use it, especially when there's disabled people involved, in ensuring that that person will be taken care of subsequent to that person's date of death, because that person in principle is actually dependent upon on you. So if you are the person that they are dependent upon, then that's basically how they make sure that that person after their date of death is actually properly looked after, and ensuring that the funds that flows to them is there to take care of them up until their date of death. And within the last will and testament, when you set up the trust deed, you can say at the date of death of the specific person, this trust will then come to an end, and you can actually say this asset will then be distributed to the following beneficiaries, because that specific trust is a special trust, registered for specific conditions, which is approved, and then subsequent to that, you cannot have the special benefits, but the subsequent beneficiaries to that specific person, they are perfectly fine and normal within the special trust. Yeah.
But just think about this living annuity question. I mean, typically if someone passes on, you get the living annuity will pay out to whoever's nominated beneficiary,
Yes.
which could that be the trust,
Yes.
essentially? So I would imagine that's probably the way.
Yes, so that is probably the way that one can also do it, and it's important to speak to that specific investment house to make sure that it is allowed that one can actually say, I can nominate a following special trust because of the special circumstances around it, and that living annuity actually pays into the special trust, and as the income flows through, it flows through directly to the beneficiary of that specific special trust. Yeah.
Okay, and then I think quite important we're talking quite a bit about trust now. I mean, the different people that sit as trustees. Why, if you think about appointing the trustees, what is important about appointing an independent trustee, and why is trustee training vitally important?
So I think people are familiar with all the court cases that came through when it comes to an independent, the importance of having an independent trustee. And what normally works well, one of the factors that will normally work well with an independent trustee is that you've got someone that's independent, that's not related to the family, that will actually make sure that the trust is run properly. They will make sure that the distributions is done, that the discretion, because I think there is this view that when we've got the trust, that everyone in this discretionary trust must be treated equally. It's a discretionary trust. So no one needs to be treated equally, because the trustees can apply their discretion on to whom to distribute the funds or to vest the funds in. And it's always good to have that independent trustee there to make sure that everything is done properly is done above board. But also what normally happens is that there are specific objectives of the settler of the trust, that the trust, that specific settler would put through in a letter of wishes, that it's not a legal document that the trustees are bound to, but it provides some degree of guidance to say, that this specific trust, I would like to make sure that it takes care of the educational needs of the children and the grandchildren, it takes care of the medical needs of them, etc. And what that helps with the independent trustee is to make sure that one can also give effect to the wishes of that specific settler. And it also helps to have the independent trustees, because there's a lot of reporting responsibilities and regulatory responsibilities as well. And an independent trustee sometimes, especially a professional independent trustee, assist with that, because when it comes to what we see now happening quite a bit is when you actually complete that trust tax return, which is quite a number of pages. In that tax return, you say that the following distribution was done to the following beneficiaries. And SARS actually go and check up that values against those beneficiaries in their personal income tax returns. And as a trustee, you are responsible to make sure that all those trust tax affairs are in order, that the financial statements has been drawn up, that the trust is in a healthy state, that the right decision gets made, that the investments are done for the benefit of the beneficiaries of the trust. So an independent trustee can play a key role in terms of making sure that the trust affairs are managed properly, managed above board, and actually there's someone that is actually there to guide the other trustees, especially when it comes to certain technical aspect that needs to be discussed. So that was the one part. There was a B part to your question.
It was around the training of the trustees.
What we notice quite a bit, and what we actually involved in, where I'm also quite a bit involved in as well, is trustee training, especially to the next generation. So what happens is the parents started the trust, or the grandparents started the trust years ago, and what they want to do is to allow the children to see how the trust gets operated, because they are going to be the future, for example, trustees of the trust. They're going to start getting more involved in the family affairs of the family, and the trust is one aspect of that as well. And what they want to do is to say, how best do we equip our children to know how to actually properly manage a trust? What is your fiduciary responsibility as a trustee? And it's to actually take them through that training to say, this is your fiduciary responsibility as a trustee. This is how you look at the trust. This is how the wealth has been accumulated. This is how we sit around the table, hold a trustee meeting, call in the portfolio managers to discuss the investment performance. How do we do distributions? How do we apply our minds in terms of applying, in terms of making distributions to whomever is supposed to receive distributions, that we can apply our discretion. So those type of training is very valuable, and I think that a lot of the parents is starting to appreciate the fact that we provide that training for the students. And some of them are still students on universities, they're about to finish, some of them did finish, and they say that we're not going to live forever. You know, we're not going to be involved in all of these things forever. So we need a next generation to actually take over from us, but we want to be part of the process of actually handing over the baton to them. But in order for us to trust them to run with this, we need to provide them the proper training. So that is the type of training we provide to the next generation, where we actually sit with them and we go through a whole trustee training with them, and we look at their trust deed, we look at their financial statements, and they start becoming part of the meeting, so they know how everything has been managed, who's the support team sitting around him from a financial perspective, from a SPW portfolio manager's perspective, who's the fiduciary teams that assist them, how do we manage this, how do we do it, how do we look after it. And that actually creates the opportunity for them to say that, sure, my parents, my grandparents actually worked extremely hard to build this wealth. How do we continue looking after it and continue building it for our children and our grandchildren? So that is some of the good things. So we do get quite a bit of feedback, which is very positive from the parents, knowing that the children actually is now getting more involved in knowing how a trust works.
Yeah, look, I think you're touching on a critical point now, and what we've seen, and if we have to take a general view across our client base, the generations of succeeding generations that are more successful at keeping the assets are people that have an understanding of the work and effort that went into building up the assets. They have some financial training to understand what the value of assets are, and
exactly,
you know, that there's no wasteful spending. So I think that's it's a very valid point, a very interesting point. That maybe just changing tack for a second. We've got some questions here on offshore wills, and if you're specifically if you're an SA resident with offshore assets, do you need a separate will for the offshore assets?
Yeah. So in principle, it's not a legal requirement to have an offshore will, but from a practical and an administration point of view, it is, in our view, an important document to have, because it helps with the ease of the administration of the offshore assets. So what we normally would find still is clients have got a only one worldwide will. Some of the clients that we see still have got Afrikaans worldwide wills, but they've got offshore assets. The amount of effort and time and the cost attached to it to actually get a will, and if it's not Afrikaans, that will must be translated into English first. We need to get that will sealed by the Master of the High Court at your date of death. Then that seal will, depending on how long it takes, which can also delay the process. We have to take it offshore, and we have to get a grant of probate to actually start dealing with the offshore estate. Now, one of the things that we also typically start picking up now is that when we've got the worldwide will, there's some of the concepts within our law, in our legislation, in terms of how we draft the will, the words that we use, the legal terminology that we use, that's not always familiar in another jurisdiction, and it actually puts speed bumps in your way in trying to effectively and efficiently administer the estate of that specific person. And then we also see quite a lot of clients that's got assets in Italy, or they've got assets in Portugal, or they've got assets in France. And if you know that you've got assets in these countries and we sit with you, part of our plan will be to draft you an offshore will, but especially if you've got assets in a jurisdiction like France or Italy, and you go visit there often, then we will normally recommend you to go sit with a solicitor in that jurisdiction to get a will drafted in that specific jurisdiction for that specific assets held there. And it actually helps quite a bit with the administration of that estate, because it's a legal person on that side who has drafted your will. They hold a copy of that will in their, if I can put it this way, native language, whether it's French or Italian, and they know the processes to follow in that specific jurisdiction. So that just eases up the whole process. And what they would normally do for us is that they will actually do that will in French and in English, or in Italian and in English, so that when we actually have to submit any documentation or the will on our side, then basically there's an English version to that. So an offshore will, in our view, it's not a legal requirement, but from an administrative point of view, it just helps to know that when we start administering your offshore estate, we can immediately start administering your local estate well. So the two estates gets administered basically at the same time, instead of the one having to wait on documentation in order for us to start the process on the other side. So it causes unnecessary delays, it causes too much back and throw from the people offshore asking us additional questions, etc. So when we can actually do it for the client, we do it properly, we draft it properly for the client, for the assets that's located abroad, and where we know that you need to speak to someone, whether it's in France or Italy and Portugal, to get your will drafted, we would normally encourage you on your trips there to actually go and sit with someone and draft those will. And normally what you will see is they will correspond with us. So we'll send them a copy of the will that we've drafted in South Africa, and then they will ask us a few questions, and then based on that they will be able to draft their wills. But the two wills doesn't cancel out each other, and basically the person sitting on that side understand what is going to take place in South Africa. Likewise, we will understand what will be taking place offshore.
And then just linking into that, how often should those wills be reviewed offshore? Are there any changes in legislation that could impact it that you need to be aware of and update those wills in the foreign jurisdiction?
So if there are any changes, it will be, so when we correspond, we normally work with solicitors offshore. So if there are any changes, then we check in with them, but we don't do all the jurisdictions. So we've got a key jurisdiction, especially like the UK will be a key jurisdiction for us. But when we tell the client you've got assets outside of that specific jurisdiction, whether it is, for example, in Italy or France, you do go and visit there on an annual basis. You do have the contact details of those people. It's always good to actually, when we do a review of all of your other affairs, is also to include that as part of your review. So my recommendation for clients would normally be when we look at your holistic affairs, when for example we've got a trustee meeting, we will also bring the wills as well and say, fine, let's just review your wills and just make sure that there was no significant changes that took place during the past year, and if there's nothing, everything stays and or remains unchanged. But if there was significant change, it's a good time for us to actually review it and make sure that we bring everything into a line, because sometimes what happens is you bequeath a property to someone, and during the year you sell the property and you get a new property, but that property is still mentioned in your will, must be removed. So those type of things that we can look at for the client. But I would suggest that every year review your will. If anything significant happens, there's a new grandchild that you want to leave something to, inform us, let us know, so that we can make those small amendments for you as well.
Get back to the trust side of things. Interesting question there. How does the trust end? Short and sweet question.
Short and sweet. So normally we look at the trust deed in terms of what the termination clause of that trust says, and then you basically have to make sure that when you want to end that trust or terminate the trust, and then basically we look at what the trust deed says in terms of terminating that specific trust. But obviously, if there's any assets within the trust, all of that will be distributed out. The trust will be empty, and then basically we will then terminate it subsequent to that. So when it comes to termination, we look at the trust deed of the trust, but there's a process to follow in terms of making sure everything has been distributed, the financial statements is up to date. And one of the things that came in, I'm not sure if it's in the past year or two, is when we terminate the trust, the Master of the High Court also requests us to get a clearance from SARS, because the Master of the High Court wants to know that the tax affairs of the trust that we are terminating is actually up to date, and is all taxes has been paid before they can actually terminate it from their side as well.
And then, a question here, you can maybe just clear it up, maybe there's some confusion. Why use a dry trust as opposed to a testamentary trust?
So offshore they don't do the testamentary trust like we do in South Africa. So their way of doing it is to actually set up a dry trust. So it's a dormant trust. So it is already there. In South Africa we deal with a testamentary trust. So that testamentary trust comes, we set it up in your last will and testament. If I take a offshore will and I say that the following people will be the executor to my offshore estate, and I say that the trust must be set up in Guernsey or in Mauritius, a testamentary trust at my date of death, then we must now all first get onto the plane, aircraft, and then we have to go into that jurisdiction. And I don't work in that jurisdiction, but I'm mentioned in the will to go there and do it. So they don't do it the way we would normally do it from when we set up a testamentary trust. So the best way of actually making sure that you've got a similar type of structure offshore that we will have in South Africa at date of death is to actually set up that dormant trust, which we call the dry trust, and then basically it will stay there ready to receive the assets at your date of death. So it actually becomes active at your date of death. It's just that you set it up way beforehand, where in South Africa it just comes into existence at your date of death. Yeah.
And then, interesting question here, can you nominate the trust as beneficiary of a life policy, and is it advisable?
Yeah, so depending, so you can, if the specific institution allows you to nominate the offshore trust or the trust as the beneficiary, then basically yes, and it will actually pay out into that specific trust, yes, at your date of death.
Okay, and then this is a question we get quite often. I'm not sure if you're going to be able to answer it. If you're not, I'll give some clarity on it. But do equity market index tracker investments like the FTSE 500 attract CITES?
That is one of the things that we need to clarify, and we're still trying to get clarity on it, because that would normally be your exchange traded funds, if I'm correct.
Correct.
And we need to check to see where has it been registered and who's the issuer. And it's difficult to find the right people that will actually say that it is a US CITES asset or it's not a US CITES asset. So we are still working on trying to find the correct person that will be able to provide us the correct advice so that we can provide the correct guidance around it. But it is still a factor where it can be registered in the US, but the issue is not in the US. So we've got certainty is when the issue is in the USA, and also it has been registered in the USA. Then we basically know that it is a US CITES asset. But where the two is in two different jurisdictions. So we are working, so we've made contact with a few people in the US. So we're just waiting on them to be able to assist us in providing us some guidance on that.
Yeah, and I think there's people also need to be aware that trackers can be in the form of an exchange traded fund or a standard CIS vehicle, and they're very different. So one has to look at the prospectus and understand the product, proper guidance
exactly,
on it.
Yeah. So you have to actually go into detail, unpack it. You have to check to see where it has been domiciled, where it has been registered, who's the issuer. So you actually have to go into detail. So it's not something that is as straightforward as looking at an Apple share. So it's a bit more challenging and complicated. Yeah.
And then talking about Guernsey and Mauritius earlier, there's a question here about cost of setting up an annual administration of a trust in a foreign jurisdiction. Now, I know that's going to vary greatly depending on the jurisdiction you're in, the provider you use, but maybe just some rough views on it. I know you're not going to have all the detailed answers on it, but maybe just some where you see the differences in the jurisdictions.
Yeah. So it depends, as you said, it depends on the jurisdiction. It depends on the charges they charge within that jurisdiction. So it's difficult to actually pinpoint to say this is it's like going to buying all world tomato sauce, and you go to Woolworths or you go to ShopRite or you go to Pick n Pay, you get the same product, but it's at a different place with a different price tag to it, with a different service that's attached to it. So it's not something we can share our fees for Sanlam Trustees International in Mauritius and setting up the trust in under Guernsey under Guernsey law as well. So that's the fees that we can share, but it's mainly dependent on as you say, on who is administering that specific trust in that specific jurisdiction and what their cost structure will be in order to perform that duties. Yeah.
But maybe have you got a view to look at that differently? At what point does your asset level justify setting up an offshore trust?
So normally when we look at encouraging or we're advising clients, to say that you can set up an offshore trust, it's when we look at what's the value of the assets, number one, that must go into that specific trust. And secondly, what you want to do is you want the income that comes out of that specific assets, whether it's dividend income, and whatever other type of income comes out of that specific investment to actually cover the expenses of that trust. Because a key thing when people come and say, but they want to set up an offshore trust, and we look at the value of the assets as well, we look at what's the purpose and the reason why you set up the offshore trust, who's going to be the beneficiaries, where they're going to be located, and we look at all of those factors, and we also look at the value. We have to ask ourselves, are we actually adding value, or are we taking value away? So if it's going to start eating into the capital of what you've placed in the trust to cover the expenses, then you have to ask yourself, do we really still want to keep it within the trust, because we have to sell off in order to pay the fees, the annual trustee responsibility fees, etc. So basically we will have to look at the value of what goes into the trust and make sure that the income it generates, that it can actually take care of itself, it's self-sufficient in terms of taking care of its own expenses.
And maybe just one last question, because I'm just worried about timing. As I said, we're going to get into load shedding in the next 5 minutes. So I just want to have maybe one last question and then just a closing remark. So maybe just high level difference in the benefits of trust versus global life plan.
Yeah. So the global life plan is as you know, is the offshore policy. So what we, for example, has got the global life plan. So from what we call the GLP. So from the GLP, the benefit there is the benefits of the tax rates within the GLP when it comes to your CGT, for example. It also what the reason why people use the GLP as well is that you can actually nominate beneficiaries, so you don't need an offshore will to administer your GLP. There is no executors fees on that GLP as well. So there is similar benefits to it. So you can actually nominate your benefits. There's no need for an offshore will.
And you can nominate the dry trust as well.
And you can also
right?
nominate the dry trust offshore as well. Where the offshore trust also, and also you're away from the CITES issues when you use the GLP. Similar to the offshore trust is as well, you're away from the CITES issues. If there's no loan account, those assets within that trust doesn't form part of your estate at date of death. You don't need an offshore will to deal with anything, because all the assets is within the offshore trust as well. So there are similar benefits in those two vehicles, and it's just that what vehicle is suitable for that client and for what the client wants to achieve at the end. Yeah. Or you can actually use, sometimes some people use a combination of the two. As you said, they will say, we've got the dry trust, we've got the GLP, and we basically nominate the dry trust as the beneficiary of the global life plan.
Stanley, I know we've got a lot of questions which we're not going to get to. Maybe just a closing remark from your side in terms of just general advice for clients. That everyone that's advisors and clients that have dialed in tonight, just a closing remark.
So just from my side, I think that trust still plays a key and important role in the global planning, but it's not for everyone. It's where it makes sense. And I think that one of the things that we need to keep in mind is when we actually start looking at making use of these vehicles, and we talk about global estate planning, is to actually stand back and to take a good look at the estate planning of the client, to see what vehicles will work for the client, what vehicles will not work for the client, what is the objective of the client, where are all the beneficiaries located. So it's more than just going and telling the client this product will work for you. Will the product work with you from a holistic point of view? And it's to review that on an annual basis, so that when there's a change or change will take place, it allows us who advises the clients enough time to actually plan properly for the client to say, let's make the relevant amendments to the structure.
Sounds like Eskom's starting in the background to tell us to close up here. So apologies for the phone call in the background. I think so. Just in closing from our side, I just want to thank everyone for dialing in tonight. As you can see, that we try to give some guidance on this, but it's a very complicated issue. There's a lot of questions that we didn't get to. We'll definitely answer these and get the communication through in the next 2 weeks. Hopefully, there'll be a recording of this webinar as well. But certainly from our side, thanks for dialing in tonight. We look forward to engaging further with yourselves and for the intermediaries that dialed in, working with yourselves and your clients to help provide some guidance. But I do encourage you to make contact with your portfolio manager in the meantime if there's any questions, that they can get those questions through to the F&T team and help you guys and everyone that's dialed in tonight deal with these issues that we discussed tonight. So thanks for your time, and we look forward to engaging again in the near future.